in the matter of HMRC and the Medpro Healthcare Ltd and others.
Yes, Mr. Watkinson.
May it please the court, I appear for the appellants, HMRC, my learned friend Mr. Lewison. The respondents are represented by my learned friends Mr. Whipple and Mr. Glover.
Yes.
We're grateful to the court for expediting this appeal. It will provide the Upper Tribunal with an authoritative statement of the extent to which it can give guidance to the FTT of the Tax Chamber on the exercise of an unfettered statutory discretion. And secondly, it will provide the FTT with an authoritative statement of the approach that they should follow when determining applications to make late appeals.
What are you actually asking us to do?
We are asking you, in terms of relief, my lord, to allow HMRC's appeal, set aside the Upper Tribunal's decision under section 14 sub 2 of the TCEA and remake it to direct that on the rehearing of the application in the FTT by a freshly constituted FTT, it is to apply the approach in Martland as followed in Khatib. Hence, at the third stage of the test in Martland, the FTT will be directed to take into account the particular importance of the need for litigation to be conducted efficiently and at proportionate cost and for statutory time limits.
Does this court need to go to that degree of detail, or if we were with you, just to set aside the Upper Tribunal decision of the judge and just say Martland stands?
Yes, that's one way of doing it. Technically, my submission is it would have to be either the Upper Tribunal's decision is set aside in some way, because my lady will be aware that there were other grounds of appeal that succeeded.
That's the problem with setting aside the decision.
But you're
The decision was to send it back to the FTT, and whatever we decide, that's going to happen.
Yes, it's the manner in which the FTT is to approach it. And so the Upper Tribunal, my lord, were clear in granting permission that it was implicit in their order.
I understand the point that you've raised.
Yeah.
It's a question of what informal terms are you. What is our order going to look like if you succeed?
So the order will look like, my lord, the appellant's appeal is allowed, the Upper Tribunal's decision is set aside, but only on ground 4, and the FTT is to follow the approach in Martland when the reconstituted tribunal hears the application.
Right. One other procedural point, actually, two. Normally you appeal against orders.
Yes.
I understand the UT doesn't actually make orders, it promulgates decisions.
Yes.
Does your right of appeal under the 2007 Act allow you to appeal against a particular reason rather than against the decision as a whole?
Well, we submit
any point of law arising out of? That's the...
We submit that we are in effect appealing against the decision as a whole, my lord, because it is the UT's decision that the appeal is to be remitted to the FTT and reheard on the basis that Martland and Khatib are wrong.
Oh, I see.
So that is why we submit that we're within this court's jurisdiction.
Right. One other point. I got a supplementary skeleton dealing with the respondent's notice, I think, a day or two ago.
My lord.
My colleagues have only just been provided with it. Why was it so late?
My lord, it was late initially to my lord because of the expedited nature of the appeal. It should have been earlier. I'd understood from my lord's clerk, and it's my fault entirely, that she had wanted the Word version of it, and so she then asked me to ensure that the office was copied into it, and that is my fault, because that was only done, I think, yesterday, and that's the reason for the delay. So I apologise.
You need permission, don't you?
I do need permission.
Mr. Whipple, do you object to our looking at the supplementary skeleton dealing with your respondent's notice point?
No, my lord.
Right, you have permission.
I'm very grateful, my lord, and I apologise. I'm also grateful to my lord for bringing our attention to the authorities of Perrin-Panathan and Flynn Farmer Limited, and we rely on them in support of the appellant's case. As my lords, my lady will know, for our part, there's one ground of appeal. My lord will have seen it in our skeleton argument, paragraph 5. By way of signposting, we propose to provide a brief summary of our submissions. Now, my lord, take the court to Martland and Khatib, then the relevant parts of the instant Upper Tribunal's decision, and then expand our submissions and offer some brief submissions on the respondent's notice in line with that supplementary schedule. So, the summary of submissions, my lord. In summary, we make 6 submissions in support of the single ground of appeal. First, we submit that the Upper Tribunal has a power to issue guidance where the relevant statutory discretion is apparently unfettered. That power stems firstly from the UT's status as a superior court of record under section 3, subsection 5 of the Tribunal's Courts Enforcement Act 2007. And we rely on Perin-Panathan at paragraph 59 as approved by the Supreme Court in Flynn Pharma Limited at paragraph 94 for the proposition that even where a statutory power conferred on a tribunal appears to be unfettered, it is appropriate for an appellate court of superior record to lay down guidance or even rules which should apply in the absence of special circumstances, so long as it is not over rigid. We also submit that, bearing in mind the UT's particular role in the tribunal system, that principle applies with at least the same force to the UT as it does to other such superior courts of record. Alternatively, we submit, my lord, that the power can be found in section 25(1) subsection A and 2 subsection C of the TCEA, under which, in relation to all other matters incidental to its functions, the UT has the same rights, privileges and authority as the High Court, and we rely for that proposition on the Senior President of Tribunal's judgment in this court in BPP case, upheld in the Supreme Court. Wherever the power is located, my lord, ultimately we submit that it exists. Secondly, in relation to the extent of that power, we submit that the UT has a general power to give guidance to FTTs to ensure that they adopt a consistent approach to procedural matters involving time limits. We submit that that power extends to giving guidance that ex ante weighting should be given to the factors in CPR 3.91, even where they are not replicated in the relevant secondary legislation, that is the tribunal's procedural rules. Again, we rely on the SPT's judgment in BPP for that proposition. We submit that the guidance of both the Upper Tribunal in McCarthy and Stone and this court in BPP, approved of by the Supreme Court, is that, in a nutshell, the approach in Denton applies in the tax tribunals. We submit that that is a broad statement of principle, and that there is no cogent reason why the power to issue guidance to that effect should not apply where the discretion to extend time is in primary legislation. So we submit that the instant Upper Tribunal's conclusion that the guidance in Martland and Khatib was essentially ultra vires tribunal without legislative change to the statutory discretion was wrong in principle. Thirdly, my lord, we submit in relation to ex ante weighting that the fact that such matters are not referred to within a broad statutory discretion does not limit the extent of the UT's powers to give guidance. Save that it should not be over rigid. We rely again, my lord, on peripanathen and paragraph 59 as later approved. We further submit, my lord, that it is common for statute to contain such unfettered discretions and for Parliament to leave the custodians of those discretions to decide on matters including weighting. And we rely on Inri Findlay as an example of that.
Well, one analogy that occurred to me was the statutory power in the Senior Courts Act to grant an injunction when it's just and convenient. And you know, from American cyanamide onwards to criteria for granting freezing orders, courts have told other courts what they should do.
Indeed, my lord, and our submission is it's an essential function of the superior courts to do just that, or their role in relation to that type of procedural matter would simply fall away. There would be no cogent approach across the board. And so we submit that it must follow that the Upper Tribunal has the power. In reality, the question here is, was it a fetter? We submit. And our fourth submission, my lord, is that the ex ante weighting in Martland and Khatib is not a fetter on the FTT's discretion. It is not over rigid, far from it. It does not automatically exclude any case or class of case from consideration, nor does it determine in and of itself the outcome of any case, because under the guidance it is clear that each case has to be considered on its own individual circumstances. And so we submit that the instant UT was wrong to conclude that the ex ante weighting in the guidance amounted to a fetter. Fifthly, my lord, we submit that the purpose of the underlying statutory time limits in the context of the tax appeals regime is to provide some certainty and finality as to the positions of HMRC as a public body, the individual taxpayer, the wider body of taxpayer, and the tribunal itself in relation to what are effectively public law proceedings that, by their very nature, have already had some procedural history under the same statute that provides for the discretion to extend time to appeal. And so, as a matter of statutory interpretation, my lord, we submit, contrary to the instant UT's conclusion that the Martland approach was permissible, gave effect to the purposes of certainty and finality, gave effect to Parliament's intention in entrusting the supervision and guidance of the appeal system to the UT, and it was correct to apply by analogy the approach to relief from sanctions, not least because that same approach applies to late notices of appeal in the civil courts. We submit that the Limitation Act and Inheritance Act, as relied heavily upon by the respondents, are quite different contexts. We submit that the authorities in relation to the particular discretions within them do not assist. Rather, they emphasise that different considerations apply depending on context. Finally, my lord, we submit that the Upper Tribunal's decision respectfully gives no sufficiently cogent reasons for its own conclusion, in which it departed from a well-established approach and did so in circumstances where the Constitution was split.
This isn't a reasons challenge, though, is it?
It's not a reasons challenge, my lord. We simply make the submission that it is in the very compressed paragraphs of my lord Mr. Justice Marcus Smith. One finds only 2 paragraphs explaining it. It doesn't seem to take into account matters such as this court's decision in BPP. It's not a reasons challenge. As to the respondents' notice, my lord, we submit that the Upper Tribunal in Martland did not err as to the general approach to judicial discretions post the Jackson reforms. We rely on this court's judgment in Yes A Electrical Ltd in Warren for the proposition that it can be said that the ethos of Denton applies even where CPR 3.9 and relief from sanctions is not engaged. Secondly, we submit that the analogy with relief from sanctions is correct, permissible. Thirdly, we submit, my lord, that unless the guidance was itself wrong in law, the appellate courts ought not to interfere with it. We rely on BPP in the Supreme Court for that proposition. I take my lord to Martland then, please. It's in Authorities Bundle 4, tab 35, page 864.
You do seem to be rather overburdened with authorities. I hope it's not going to be necessary to look at them all, because you've only got a day.
Yes, for my part, it won't be.
What? I'm doing it electronically.
It should be
Number
PDF
35,
864.
tab 35. Yeah.
Yes, my lady. For Martland, concern an application to make a late appeal against an assessment to excise duty. Take court's page 872, please. Paragraph 18. The Upper Tribunal noted that it was that whether to or not to permit a late appeal, the FTT is exercising a discretion conferred on it by statute, not a case management decision. 19 wasn't appropriate to regard the exercise as a direct application of Rule 2, but the principle embodied in the overriding objective applied just as much to the exercise of such a judicial discretion. 24 on page 873, please. The Upper Tribunal noted that that discretion is at large. But 25, that the Upper Tribunal had stepped in to provide guidance. And thereafter, the Upper Tribunal considered the guidance in 2 earlier cases. The one goes on to page 877, please. Paragraph 34 at the bottom, my lord. Notes the purpose of the time limit to bring finality. That is a matter of public interest from the point of view of the taxpayer in question and the wider body of taxpayers. Thereafter, 37, the UT set out CPR 3.9, page 878, paragraph 38, it noted that it had been amended. Paragraph 39, the UT said that that rule represented the main point of connection between the authorities it had considered and the well-known and wider stream of authority on relief and sanctions and extensions of time in connection with procedural rules of courts and tribunals. And then 879, please, my lord, paragraph 43 is the reasoning of the Upper Tribunal as to why it considered that the approach to relief from sanctions should also apply, saying whether considering an application which is made directly under Rule 3.9 or an application to notify an appeal to the FTT outside the statutory time limit, it's clear that the judge will be exercising a judicial discretion, and then setting out the consequences could be the same. Hence the analogy with relief from sanctions. We submit that that is cogent reasoning, and indeed no other Upper Tribunal, including the instant Upper Tribunal, has disagreed with the aptness of applying the Denton approach, far from it. Guidance is then set out at paragraph 44 on page 879, running over to paragraph 45 on the next page, and that is the part in issue in this appeal, whether the first sentence was wrong. The Upper Tribunal then followed Markland in Khatib. I don't need to take you to that. I turn then to the instant Upper Tribunal's decision, please. It's in the core bundle, my lord, paragraph 10. And ask the court to go to page 92, please. There were ultimately 4 grounds of appeal. Ground 4 is set out at para 11, subpara 4. The UC noted that, as pleaded at paragraph 12, it was a narrow attack on the correctness of the decision in Khatib. But at 13, it had primarily evolved into an attack on Markland. The UT recently did not deal with the general rule in Khatib or stated it was wrong. The analysis of round 4 begins at page 107, please.
So just pausing for a moment.
Yes, my lord.
Round 4, as pleaded,
Yes.
was not saying that the UT had no power to give guidance. It was just saying that the guidance that had been given was wrong.
It was saying that the guidance given in Khatib, which was about the general rule of, if I can put it informally, the sin of the advisor is
Yes.
to apply, was wrong, but that then evolved into the distinct point which one sees at the bottom of paragraph 13, my lord.
Yes.
Whether the UT has taken a wrong turn in Markland and subsequent cases is a distinct point
So,
which we consider last.
the power of the Upper Tribunal to give guidance at all was a point that was argued in front of the Upper Tribunal, was it?
I'll have to defer to Mr. Millington, who was below when I wasn't, by the way. So I understand it, by the way. It wasn't that there was no power. It was that the power did not extend to the statutory
Oh, I see.
discretion.
So the point that Mr. Justice Marcus Smith decided was argued in front of the Upper Tribunal.
Yes.
Right.
But one sees, my lord, the footnote, the footnote 6 at the bottom here reflects the evolution of that.
Yeah.
So it wasn't as it originally was, but it ended up being Markland is wrong.
Yeah. Right.
So the The analysis of ground 4 begins at page 107, my lord. Noting at paragraph 82 that the provision had to be construed in context.
Yeah.
At
You can
84
take it that we have read this.
I'm very grateful. In that case, I can go straight, my lord, to 90, simply for my lord's note, page 109, that the Denton approach was apt. And then my lord, Justice Marcus Smith's reasons for allowing the appeal are page 110, paragraphs 96 to 97. And my lord will have seen the dissenting judgment as well, 99 to 100.
Yes.
In essence, the UT decided that because the CPR 3.91 factors were not written into the legislation, then the UT in Markland followed a critique that exceeded their powers. My lord, turning to the first submission, my lord will have seen in our skeleton argument, paragraph 14, we cited a consultation paper in relation to the implementation of part 1 of the TCEA. Whilst of course it's not the statute itself, we do submit it does assist in identifying the policy objective behind the creation of the UT and its intended functions. There are 2 sections we would like the court to consider. In our authorities bundle, volume 4, please, tab 42, page 1068.
Tab 43, transforming tribunals, is it that?
Yes, my lady.
Starting at 1032, yeah.
Starts at 1032. Can I ask the court to go straight to 1068, please?
Yeah. This is what you quote.
Yes. Paragraph 178.
Yeah.
And there's one further section, my lord, page 1071. Paras 190 to 192.
Yes.
So in essence, my lord, we submit that the broad policy objective was to entrust the supervision of the new tribunal system primarily to the UT, to have at least the same position in the judicial hierarchy as the administrative court, to play a central, innovative and defining role, and that included giving authoritative guidance on all issues on which the FTT needed it.
Yeah.
That was then given effect to in the TCEA.
The document we've just been looking at was in effect the government's response to the Leggett report.
Yes. Well, we don't have the provisions of the TCEA that we can track those objectives into. That's in the first volume of authorities. Tab 6, please. Page 22. You have there, my lord, section 3 of the TCEA, subsection 2 creates the UT, subsection 5 sets out that it's to be a superior court of record.
Yeah.
Page 23, under section 12, sub 2B2, that power extends to remaking a decision. has a judicial review jurisdiction under section 15, that's page 27. Page 30 provides the authority to make the tribunal rules, that's in section 22. And one sees that the power, section 22, sub 4C and E are aimed at speed of handling of cases and their efficiency. Then, my lord, page 32, section 25. That is the section that provides for the UT in relation to the matters in subsection 2, including C, all other matters incidental to the UT's functions, to have the same powers, rights, privileges and authority as the High Court. 25 sub 3b, it's not to be taken to be limited by anything in the tribunal procedure rules other than express limitation. I'll take my lord to page 39, please. This is schedule 5 to the Act. Paragraph 4 in relation to time limits notes that rules may make provision for time limits as respects initiating or taking any step in proceedings before the FTT or UT. We submit that there's no intention to draw a bright line between a statutory discretion to extend time to make an appeal and an application within proceedings to extend time to take some step. For completeness then, my lord, in the same bundle, tab 10, page 117, please. That is Rule 20 of the FTT rules, which builds Rule 20 sub 4 on the notice of appeal provisions, providing over the page 118.
It's FTT rules.
Yes, 20 sub 4b at the top of 118, unless the tribunal gives permission, the tribunal must not admit the appeal.
So that's your wide open, unfettered, that's the discretion point, is it?
The discretion is within the statute itself,
Right.
my lady, so that's in this instance within the Value Added Tax Act, that's in volume 1, tab 5, page 20.
Yeah.
That's the instant discretion. There are
Section 83, of course, yeah.
other discretions, it's simply an open permission provision. So in relation to the powers of the Superior Court of Record, we rely on Perrin Panathan. That is in the supplementary bundle, please, tab 46, page 119. My lord can see from the head note that concerned the refusal of the Magistrates' Court to order costs in favour of the appellant.
Yeah.
Under section 64 of the MCA 1980, on the basis that in the forfeiture proceedings the police had had reasonable grounds for their suspicion that the cash had been intended for use in unlawful conduct, the actual discretion under consideration one can see at page 1127. Paragraph 12, that's section 64.
1127, 12.
Paragraph 12 sets out section 64 of the Magistrates' Courts Act, my lady. So that is the broad discretion being exercised to audit costs. Thereafter, the court considered the principles in Bradford Metropolitan District Council for our purposes, unless my lord invites me to, I will be going to go to the contents of the principle. I'm grateful. We then go to page 1146, please. The Master of the Rolls added an additional judgment in paragraph 50, and then over the page at 1147, paragraphs 58 to 59, to which my Lord Justice Lewison drew our attention.
Yes.
So we rely on 59 at H.
Yes, and Lord Justice Morris Kay, paragraph 49, said he agreed.
Yes. And further, my Lord, over at page 1148, paragraph 64, right at the bottom, in terms of those principles, the last sentence there, the Master of the Rolls went on to say that unless satisfied that these were wrong, and bearing in mind that they've been accepted and applied for some 20 years, then it would require a particularly good reason to override them. My Lord, that, as my Lord will know, was then upheld by way of an approach in the CMA and Flynn Pharma Limited and another, 2022. That's within the same bundle, please. Beginning at page 1169. So, my Lord, I don't propose to go to the principle being considered there, simply the endorsement, unless my Lord would require other assistance in relation to that. It's considering the CAT's approach as to costs instead.
Yeah. That's Lady Rose at paragraph 94.
Yes, my Lord, yes. That endorses it. So that's page 1196. Can I also invite the court to page 1197, please? Paragraph 97. Because what Lady Rose went on to do there from B onwards, especially at the bottom of the paragraph, was effectively to give ex-ante weighting to the risk of the chilling effect in the types of proceedings dealt with in Booth, Baxendale, Walker, and Perrin-Panathon. So licensing, disciplinary proceedings, and cash seizure type proceedings. So that we do submit as an example of the highest of the superior courts setting out guidance on ex-ante weighting that is permissible. But not too over-rigid.
Is this weighting, or is this just something which you should take into account?
We submit that it amounts to weighting because it says in terms that there's a general risk of a chilling effect. So one starts from the point that that is applicable in those proceedings, as opposed to the approach in the CAT and below, which was different.
Yes.
So we submit, my Lord, based on those authorities, that the fact that the statutory discretion contains no fetter on it does not mean that a superior court of record can't lay down guidance or rules which should apply, at least in the absence of special circumstances, as long as they're not too rigid. They strike the balance between flexibility and certainty, and that ex-ante weighting itself is not impermissible, again, as long as it strikes the correct balance.
Yeah.
So turning to the particular authorities on guidance given by the UT, my Lord, we've cited 3, but I can take, my Lord, simply to BPP in the Supreme Court, because that will be authority for the proposition that the guidance that can be given by the Upper Tribunal extends to matters such as time limits and extends to the ability to give ex ante weighting, effectively to incorporate by analogy the factors in CPR 3.91.
Yes.
As my Lord will know, there were two divergent UT decisions that were considered, the first of which was McCarthy and Stone. My Lord's and my Lady have probably read that.
Well, there's McCarthy and Stone on the one hand and Leeds on the other.
Leeds on the other, and McCarthy and Stone, the decision was CPR 3.9 applies by analogy, and Data Select, the earlier decision applying CPR 3.9, was
In its then form.
Forgive me?
In its then form.
In its then
Well, the
form.
point about McCarthy and Stone was that Judge Sinfield decided that since the change to CPR 3.9, that changed version should likewise be applied, but Judge Bishop thought that because the the tribunal rules hadn't changed, then the position should stay as it was.
Quite well. And Judge Sinfield was Judge Sinfield was content to apply the general rule. Relief and sanction.
The Court of Appeal had to choose between them, and it chose McCarthy and Stone.
Yes. Can I take my Lord briefly to the Court of Appeal and BPP then, please? That is in our volume 3 of the authorities bundle, please.
And we're going first to this court rather than the Supreme Court, are we?
Yes, yes, my Lord, to see what that court then went on to approve. Tab 32, page 825. Of course, my Lord, the composition included the senior president of tribunals, then my Lord Justice Ryder, who gave judgments of the court with which my Lords Justice Bacon Richards has then was agreed. Page 827, para 2, the background to that, my Lord, was that an application to make a debarring order against HMRC. We set out the effect of the FTT and UT's decisions in our skeleton at 38, but in essence, my Lord will know that the FTT considered that the guidance that was then in Mitchell should be applied by analogy and went on to accord the factors in CPR 3.91A and B significant weight as part of the overriding objective, and then debarred HMRC, who appealed to the UT. Judge Bishop followed his same approach in Leeds, saying that there's no warrant for incorporating those factors absent change of rules. And then goes to page 830, please. Paragraphs 15 through 17, Lord Justice Ryder deals with the conflicting decisions in McCarthy and Stone and Leeds. 16, the key question could be characterised as whether the stricter approach to compliance with rules and directions made under the CPR applies to cases in tax tribunals. His Lordship was of a firm view that the stricter approach is right, and then set out the reasons endorsing, in effect, McCarthy and Stone.
Yeah.
If one goes over to 832, please, paragraph 23. Despite the fact that the CPR do not apply to the tribunals, and the words in their respective rules were different, and there was no equivalent to CPR 3.9. And then at page 833, please, paragraph 25, His Lordship deals with section 25 of the TCEA, setting out at E that under section 3.5 of the TCEA, the UT is a superior court of record. its rulings on points of law are binding on the FTT, and it's both the practice of and the power inherent in that court to give appropriate guidance. And then setting out, if there's any doubt about that, look at the express requirement for a limiting provision in 25(3)(b). My lord will have seen the taxpayers' submissions set out at 26. HMRC submissions were over the page at 28C, effectively making Judge Bishop's argument the tribunal's rules haven't been amended. Page 835 then please. Paragraph 32, just under F. And His Lordship determined.
Sorry, I've lost my place.
Forgive me.
Paragraph.
32, my lady, on page 835.
Yeah.
Between F and G, in the circumstance that the tax tribunals were silent on the question, there was no error of law in Judge Mosedale's approach in the FTT. And then from paragraph 35 on the same page, setting out the UT's status as a superior court of record, how it could take its own view on interpretation, develop its own precedent, and it was not precluded from giving guidance on practice and procedure simply because the TPC hadn't done so. And then commenting on the limiting provision that His Lordship had referred to in paragraph 25. That then concludes at B. There was nothing about that case or McCarthy and Stone or Leeds that suggests that they were inappropriate cases in which interpretative guidance could be given. 37 to 38, returning to the fact that there was nothing in the wording of the FTT rules justifying a different approach, effectively did not matter. Setting out at 38 the reasons behind that in terms of policy, if I can call it that. Then page 837, please, paragraph 44, His Lordship considered data select. It wasn't an appropriate case to analyse it, but the final sentence was, if His Lordship had been minded to, would have created a further difficulty for HMRC, because Mr. Justice Morgan had applied CPR 3.9 by analogy without waiting for the TPC to amend the rules in the manner that he had just suggested was appropriate. So that's PPP in this court. We then move on to the Supreme Court's decision on that. Within the same bundle, please, the next tab, actually the very next page. I can ask the court to go straight to page 848, please. Paragraphs 25 and 26. The Supreme Court upheld Lord Justice Ryder's judgment, saying that Judge Sinfield had given guidance in McCarthy and Stone. 26, it wasn't for this court, the Supreme Court, to interfere with the guidance given by the Upper Tribunal and the Court of Appeal as to the proper approach to be adopted by the FTT in relation to the lifting or imposing of sanctions for failures to comply with time limits, save in the very unlikely event of such guidance being wrong in law. That paragraph then concluding in F. In a nutshell, the cases on time limits and sanctions in the CPR do not apply directly, but the tribunal should generally follow a similar approach.
Yes.
So we submit from those two authorities, my lord, UT is a superior court of record, has the same powers, rights and privileges and authority as the High Court. It's there to give binding rulings. Practice of and power inherent in such a court to do so. UT rules don't limit it. Compliance with procedural time limits is an appropriate case in which interpretative guidance can be given. Guidance power clearly extends to giving guidance to the FTT on the exercise of a procedural discretion under the rules, including requiring the FTT, as part of that guidance, to give ex ante weighting to the factors in CPR 3.91, even though they're not in the rules. General approach in data select, applying CPR 3.9 by analogy to admit a late appeal is appropriate. And the stricter approach in Mitchell and Denton applies generally to cases in the tax tribunal. As to the latter, my lord, we submit that that is a broad statement of principle. It's not simply confined to rules-based discretion. My lord will have seen in our skeleton, paragraph 62 to 3, we also refer to an FTT case. Ordinarily we wouldn't. We do so because of the composition of it.
Yes, I saw that.
Which was included the now senior president of tribunals. Can I take my lord's that briefly, if you insist?
Just help me on this. Presumably the approach that you are advocating would apply across the board in all tribunals, not just the tax tribunal.
Yes, my lord. We've noted that the effect of this appeal may go wider, but it depends on the individual upper tribunal. So the individual upper tribunal may wish to give guidance in another chamber to say.
Right. So the administrative chamber or the lands chamber could give different guidance.
They could. So we're not inviting this court on behalf of the appellants to say this approach must be adopted in all tribunals.
So just thinking about the wider ramifications, your point is that the upper tribunal of any particular chamber is empowered to give guidance, and what guidance they give, well, it's not is up to them. So a different approach might be justified in the immigration chamber, for instance, or the lands chamber.
So effectively, my lord, it's when the upper tribunal decides in Martland that this is appropriate, if there's nothing wrong with the guidance, there's nothing wrong with the guidance. It really comes down to that, and the spill out effect, my lord, is if the court were to decide that the upper tribunal just doesn't have the power to give that kind of guidance, because that would then send the signal to the other UTs. You can't interfere where there's a statutory discretion by way of guidance, or if you do, you are limited to the type of guidance that you can give. And that is effectively why, being candid, my lord, the appellants bring this appeal. If this court says Medpro approach is right, then so be it. But in terms of upper tribunals being cut down in terms of their guidance function, that we submit is the important point of principle, which is why the upper tribunal gave permission. So that's the spillover. Lands Luo, briefly, please, my lord. That's in volume 4. Please, tab 42. My lady, page 101. Go to page 1029, please. Paragraph 68, the composition noted halfway through that paragraph that in Mr. Justice Marcus Smith's decision there did not appear to be any assessment of Lord Justice Ryder's approach to CPR 3.9 or his endorsement of the stricter approach set out in Mitchell. And then at 71, the Lands Luo Tribunal applied the stricter approach in Martland because it seemed to that tribunal that the approach was consistent with the approach of this court in BPP, which was affirmed or permitted by the Supreme Court. And at the bottom, it seemed to that composition that it was a statement of general application to the exercise of such discretions by the FTT TAC. We submit that that observation was correct.
What, they say that we will cross-check our decision against the test set out in Medpro. What is that test?
That test is to revert to data select effect. So the old CPR 3.9. So when Mr. Justice Marcus Smith had said section 83G of VATA tracks the old CPR 3.9.
Is that what he said?
Yes.
I thought his point was you couldn't have any guidance, whether from data select or anything else.
Well, yes, he also says that the statute itself tracks old CPR 3.9.
Yes, well, I didn't quite understand why he said that.
No.
The statute doesn't appear to track anything.
No, my lord, and that's our submission. It's simply a broad discretion. So that's Lands Luo, which we submit reflects the modern approach to litigation. The ethos of Denton applies even where CPR 3.9 relief from sanctions is not engaged, and that's this court's judgment in Yes Electric. So we do submit, my lord, that applying Perimpathan endorsed in Flynn Farmer, that the statutory discretion containing no fetter does not mean the UT could not give this guidance. Alternatively, one can find the power located in section 25 of the TCEA. Bearing in mind,
just go back a step.
forgive me, my
Sorry, can I just go back to that last point my lord raised? So the point that Marcus Smith J was making was really quite a small point. He didn't like the additional extra weight accorded, it's paragraph 91 of the Upper Tribunal, his judgment. He didn't like the extra weight that were afforded to the two new factors in CPR 3.9.
yes, my lord.
That's what he was saying. So
Yeah.
You can pull in the old factors.
Yeah.
Query how on his analysis, but you can do that. But what you can't, what I'm not having, is the idea that you read in extra things that have since come in.
Exactly. So the approach is fine. Martland's fine, save for when you get to applying
Table
CPR
point.
3.91 and the two factors and giving them particular importance. That was what his lordship was.
And those two factors are the point about proportionality and observance of rules.
Yes, effectively. So giving particular respect to the need for efficient conduct of litigation and costs, and giving particular importance to the need to apply the time in.
And did Martland say that that was a particular issue, or just that you take those things into account?
Martland, my lady, said that they were to be given particular importance.
The starting point, yeah, para 45, that balancing exercise should take into account the particular importance of those two. But it's not saying it's first amongst equals, is it? It's just saying you've really got to look at these 2 points.
In the same way as the court in Denton had said on an application for relief from sanctions, that those are points to be given specific weight because of their importance, but they're not ruling anything out. They're not fetching.
No, I mean there just is a sense of the Marcus Smith J judgment of sort of over-analysis that he understands that it's become very prescriptive about the sequence and the weight and all the rest of it. And you might say that that was a misunderstanding, that Martin's not telling you where you put the weight and what order you do it in. It's just saying these are the factors you look at. And in particular, you've got to look at efficient conduct of litigation, proportionate costs and statutory time limits, but quite how you weigh that is a matter for you, FTT.
Yeah, it is saying doubtless in our submission that you are to give particular weight to those two matters, but that's as far as it goes.
Because you might say if it went any further than that, that would be to fetter.
Yes.
You can't do that.
No. But if something had ossified into a rule, for example, that if your appeal is 4 years late, we won't entertain an application, one could see that would be a fetter on the discretion. there is nothing amounting to that we submit in the Martland guidance or when it was followed by Catevas.
So is Marcus Smith J right to talk about additional extra weight to be accorded to the points A and B under the new CPR 3.0? Was that an overreading of what Martin's ever said, Martin said?
So Martland, I can do no better than take my lady to the particular paragraph, which is 45.
Yeah, I'm there. It doesn't seem to me that, is it Judge Berner?
It's Judge Berner.
Judge Berner is doing anything. He's not saying there's additional or extra weight to those two factors. He's not saying you put those first or you give them particular weight. He's just saying it's a balancing exercise. And you have there's particular importance. Focus on these two factors. I mean, maybe we're sort of splitting hairs a bit, but I'm just a bit foxed by what happened in the Upper Tribunal here, I suppose. Or what Judge Marcus Smith J said.
Yes, and that's a difficulty in analysing what in fact his lordship's reasons were for. On one view it seems to be there wasn't the power to give the guidance, on another view it seemed to be the guidance itself amounted to a fetter. And then saying that in fact the Act trapped a different part of CPR 3.9 that's not.
Well, that's obviously not right.
That's not in it. That's the difficulty we're in, but the basic effect of Martland was simply to apply by analogy factors in 3.9 CPR as one would do in an application for relief from sanction.
Can I just ask you about another bit of the Upper Tribunal's decision, which I found difficult to understand? If you go to paragraph 90,
Yes,
page 189, we're still in the common ground at this point of the decision. And what they say is the question is whether the approach is permitted as a matter of statutory construction, 83G6. And if that has elevated the CPR 3.9 A and B factors to a more prominent position, then that approach needs to be justified by, or at least not be inconsistent with the words of the statute. What inconsistency did Mr. Justice Marcus Smith find?
The inconsistency appears simply, my lord, in our submission to be that CPR 3.91 factors were not written into the legislation. That's the only inconsistency that is readily divinable from the judgment. That seems to be the effect in our submission of paragraph 97, saying that section 83G6 tracks not the new version of CPR 3.9 but the old. It seems to be saying that within the statutory discretion, unless you legislate to import 3.91 factors, they can't be given particular importance. But even, my lord, the notion of inconsistency with the words of the statute we submit is difficult because, like my lord's analogy, there are a number of very broad statutory discretions that will not contain the wording of the guidance of any superior court. And that is a difficulty we submit with the reasoning here. It's not a reasons challenge, but in terms of departing from an established and cogent approach, it seems to be to say, if one carries out a textual analysis of the discretion, one won't find the guidance in it. But that applies to almost any broad statutory discretion.
Right.
So we do submit, my lord, bearing in mind the Upper Tribunal's particular role as well in this system, that the principle in paragraph applies with at least the same force, and there's everything to be said for the Upper Tribunal giving guidance on a statutory discretion, in the same way as the superior courts do in other contexts, to secure the coherent and consistent exercise of the discretion to produce capricious outcomes, and for both parties to understand the approach that will be taken. So we submit that the Upper Tribunal's decision, apparently to the effect that absent some legislative change to batter the Upper Tribunal's power did not go that far, was wrong. The response to those submissions from the respondents proceed as if BPP in the Court of Appeal, for example, did not exist. Instead, they make submissions on depriving courts themselves of wide and unfettered discretions in various contexts, including the Limitation Act and the Inheritance Act. And we submit that they just don't assist in this context.
Why not? Because they are doing different things, aren't they?
They're doing different things. So if one looks at the Limitation Act, that's permitting inter partes proceedings of a certain nature to be brought between the two parties beyond the time limit for particular reasons that need to be looked at when exercising the discretion. Here we submit that the system is dealing with an appeal. There's a particular public law procedural system set out in the statute. HMRC make a decision. There's then inbuilt into that, as my lady will know, the hope of review. So a dispute resolution type procedure within the statute.
You have to have that now, don't you? You can't.
You have to offer it.
I see.
HMRC have to offer it. You don't have to accept
I
it.
see.
But if you do, you can't appeal to the FTT until the review's concluded or been deemed to be concluded.
Yeah, then your time runs from the...
Then your time runs. So the time limit is set up now to run from, if you do review, the date of the review. So you have a linear system of decision, hopefully review. If you don't like the review, appeal. That's by a notice of appeal against an extant decision within the procedural system of the FTT, and that then goes into the FTT. So we submit that it's quite a radically different context from ordinary inter partes civil litigation. Even the way the Limitation Act works, as I understand it, is different in that it really provides a time bar defence. It doesn't actually provide that someone can't make a claim. It's looked at in a different way. The same with the Inheritance Tax Act. The provision relied upon is a 6-month provision in which one can change the financial settlement that's happening under the administration of probate. Again, radically different context we submit, and one that has completely different circumstances that the court might wish to take into account. It doesn't have that public law element of an appeals structure against decisions. Perhaps having heard my own friend in relation to those authorities, I can unpack those submissions more if it's good assistance.
Yeah.
So looking then at the extent of the Upper Tribunal's power to issue guidance, we submit, my lord, that from BPP, which followed Jones and Pendragon, it's well established that...
You don't need to repeat the submissions you've already made.
Oh, I'm very grateful, my lord. And then in relation to ex ante waiting, my lord, the only additional point on that is in re Findlay. My lord perhaps has the point that it's broad statutory discretion afforded to a minister in that instance, where he's able to put particular weight on the length of a sentence that someone's serving in order to exercise his discretion. It's perhaps the same point, and I don't need to trouble my lord with it. In relation to fetter, my lord has the submissions on that, and again, we've set out additional authorities, but I perhaps don't need to take my lord's time if I just set out the principle. It's well established that it shouldn't be rigid, so rigid to amount to a fetter. It is essential that each case is considered on its own circumstances. the policy doesn't determine the outcome. Something that excludes classes of cases, effectively. And when one applies Markland, as my lady has come back to paragraph 45, it's not a fet, is our submission.
And just on that point, what all Markland says is you apply Denton and White, isn't it?
Yes.
So
Right.
the principles are actually in Denton and White.
Yes.
And in Denton and White, I think the Court of Appeal was saying that particular weight must be given to these factors.
Yes, particular importance. So there.
Particular importance, or I think they do talk about particular weight at one point. There's a passage in which is actually picked up in paragraph 75 of the decision in this case, page 106, where
Yes, my lord.
it's the top table point, and they say they reject the Bar Council's submission, which by that is meant that the specified factors are not to be given particular weight.
Yes. So it is a matter of particular weight. They use the word importance or weight is
It's interchangeable.
interchangeable in our submission. So there's no doubt that the Upper Tribunal in Markland is seeking to apply by analogy the Denton approach.
You don't want a ruling from this court saying everything's up in the air and you just do the checklist. That's the old 3.9.
Effectively,
So this is a way of saying Denton and White applies via Markland to this particular discretion.
yes. Unless the court takes the view that that's a problem in terms of fettering or fundamental approach. In relation to fundamental approach, my lord, we do submit the position in the civil courts is analogous in terms of notices of appeal. It's clear from the judgment of this court in Hysage applying
Yes.
the earlier decision in Sayers that if you have a late notice of appeal in the civil court system, it is approached in the same way, the same rigorous approach as relief from sanctions. And we submit that the reasoning is apt to apply by analogy to late notices of appeal in these types of procedures. My lord has submission 6. My lord has our general points on the respondent's notice that I can unpack further and reply if it would be of assistance to my lord.
Yeah.
And my lord knows the relief that we seek from this court. Might I turn my back?
Sure.
Those are our submissions.
Mr. Millington, do you want to add anything?
No, thank you.
Yes, Mr. Windle.
Thank you. Bear with me while I shuffle my technology about. Thank you, my lord. One very brief housekeeping point first. The FTT decision wasn't published and isn't publicly available at the request of the respondents because it contained details about Mr. Repry's health.
Sorry, that's what?
It contained details about Mr. Repry's ill health,
Right.
and the Upper Tribunal agreed not to refer to that in its decision. I don't see any particular reason you would need to
Well,
refer
we're
to
asked to
that.
decide a point of principle.
Yes.
Detailed facts don't matter in the slightest.
Thank you, my lord. What I propose to do is take you briefly through the legislative scheme. I don't think you have been shown section 83G in much detail yet. And then talk about the way that that scheme was understood before Markland, because there's 2 sea changes here. There was first was in Markland, where there was a well-established approach, and that was cast aside. And then have a very brief look at Martland before turning to why we say that there are limits on what courts can do in terms of restricting broad discretions or evaluative judgments, and explain why we say the cases BPP, Perrin Panathan, and Flynn don't expand to the sort of discretion that you're considering in this case. And the fundamental reason, not to leave any suspense, is that we say that where the courts are dealing with procedure, they have an inherent jurisdiction to regulate their own procedure, and that broadly allows them to fill in the gaps. Where instead they're dealing with substantive discretions and evaluative judgments, they are much more closely tied to the purpose of the legislation or language of the legislation construed purposefully in its context. And we say there is a meaningful difference there. If we then begin with section 83G, which is at page 20.
Just the distinction is between procedure on the one hand.
Yes.
And what was the other one?
Substantive or jurisdictional discretions and evaluative judgments.
So, an application for permission to bring proceedings under the Inheritance, Family Provision, etc. Act, that falls into your second category, is it?
Yes, that's a substantive decision for the court to make.
So, the Court of Appeal can't give any guidance to a lower court on how to approach that question.
It can give guidance. What it can't do is give guidance that steps beyond seeking to allow the legislative purpose and the language of the legislation to be understood. So, and perhaps then this is a help point to start. We, of course, accept that all courts can and do give guidance. The question is where guidance strays into something that is quasi-legislative, that it's stepping beyond the legislation and creating new rules. And say it's all courts, when faced with the decision, make a decision, explain their reasoning, and appellate courts, that reasoning will be relied on by lower courts. Similarly, all courts, or appellate courts generally say, here is how we would approach this, here are factors that might be important, here are factors that won't be important, and we say that's all fine. What goes further is when the court makes something that is more akin to a policy decision and says, we can't detect, or without seeking to detect any support in the language or purpose or context of legislation, but we're going to apply this in a particular way, we're going to lay down what are effectively rules. And we say that's what the Upper Tribunal did in McCarthy and Stone. And in Martland, that in both those cases there was an established approach in the Upper Tribunal, and I'll show you Aberdeen City and Data Select in a minute. And the Upper Tribunal departed from those decisions without any change to legislation, without saying those decisions have misunderstood the legislation, but simply said in future, the Upper Tribunal is going to take a different approach to a statutory or to a discretion.
So is it part of your case that McCarthy and Stone is wrong?
No, because McCarthy and Stone is about procedure. So we say McCarthy and Stone BPP, because it was about the Upper Tribunal regulating the procedure of the tax tribunals, is entirely permissible. We have to, but we say anyway that procedural, the inherent jurisdiction to regulate procedure gives courts a greater power to fill in gaps in legislation. But where we're outside that, unless you can divine some sort of power from somewhere else, then courts are much more closely tied to giving guidance on the meaning of the language and purpose of legislation.
I'm not sure I'm quite understanding what your position is. Are you saying that when a power such as the one we are considering is in issue, the Upper Tribunal can give no guidance, or that it can give guidance, but there is a limit to what guidance it can give?
The second, my lord, I'm saying it can explain what the purpose of the legislation is for, what the language requires. It can, as happened in both Dataselect and Markland, set out an approach to applying the discretion to help avoid errors of law. It can say that certain factors either will be relevant or are likely to be relevant. It can say certain factors won't or are unlikely to be relevant. But in all cases, that's tied back to actually construing the legislation itself. What it can't do is say, unconnected with legislation, unmoored from any construction or purpose, we're going to impose rules on how you approach that discretion.
So what does that come to? That you can say, as a matter of construction of section 83G, that factors of efficient dispatch of litigation and finality may be relevant, but what you can't do is to say that they should be accorded particular weight. Is that where you draw the line?
I think I would say that you, depending on your construction of legislation, you could say either. As it happens in this case, I'd say that the efficient dispatch of litigation is not relevant at all to a power that concerns starting litigation. But I'm saying what you do is you go to the legislation and you construe the words, you think about the purpose, you look at the broad context, and you then apply the power that the legislature has chosen to give you, rather than saying we've got this broad power, we're now going to lay on top of it a system for how we have decided as a matter of policy it should be applied.
Which particular words are we construing?
83G is at page 21 of the authorities funding.
We're construing if the tribunal gives permission to do so.
Yes, in the context of that legislation.
I don't understand what construction, what interpretation you give to that other than what it says on the tin.
Well, my broad answer is that's what you do, that it's a discretion at large for the FTT to...
But then that's inconsistent with your proposition that the Upper Tribunal can give guidance.
I would suggest that looking at that, the Upper Tribunal, the guidance that we have been given by the Upper Tribunal, I can show you that in a minute, is guidance that things like the length of the delay, the reason for the delay, the prejudice to each party are likely to be relevant wherever there's a long stop date and permission to go beyond it.
Where do you get that from out of the words?
Well, not out of the words themselves, out of the purpose of having the structure of legislation. What you have in 83G is time limits that start running at various points, either from the appealable decision or from the review conclusion or when the review should have concluded. And then there's a 30-day time period where you have a right to bring an appeal. And then there's a broad discretion to let the FTT, or for the FTT to allow a person to bring an appeal after that. And so you look at that and you ask why the FTT has been given that, why there is a 30-day time period, why the FTT has been given a discretion. And it's reasonable to conclude, and it's what previous courts have concluded, that finality is important. There's a value in the revenue being able to conclude this case as concluded. There's a difficulty the longer something goes on about whether evidence will be lost. And so you weigh those sort of factors in the balance, and then the court decides whether it's fair, in a broad judicial sense, to allow the appeal to commence after the 30-day period.
Would those words allow the Upper Tribunal to say, in every case, the reasons for the delay must be given?
Must be given. I don't think it would say they must be given. I think it would probably say that in the absence of any reasons, you're going to be looking for fairly serious prejudice to the taxpayer, unless it's a very short delay.
It won't I thought we were shown a provision earlier on which said, from the FTT rules, which said that where the taxpayer is seeking to appeal out of time, they have to state the reason, don't they? Have I misremembered that?
That is page 117.
So that's that's a rule which is contained in a. So that's a mandatory obligation, is it?
Yes, that's a mandatory obligation in the tribunal procedure rules.
So do you say that is ultra vires,
No,
the statute?
the tribunal procedure rules give the FTT or give the tribunal procedure committee power to create, or the, sorry, let me start again. The TCEA gives the tribunal procedure committee the power to create these rules. The TCEA will say what you need to do to commence proceedings in the FTT in exactly the same way as if you want to issue proceedings in the High Court. There are conditions you have to meet, you have to fill in particular forms. And I would say that requiring an application for a late appeal to include an explanation of the reasons for the delay is consistent with the power to create rules for starting proceedings in the FTT. So it's within the power of the Tribunal Procedure Committee granted by the TCEA.
But it's not in the underlying statute.
It's not
It's
in.
not in the.
It's not in the VAT Act, no. But it's.
So does that cut across the VAT Act?
No, I think we say that is it's the same as saying you've got to provide various details in the form. You've got to provide contact details, an explanation of the grounds of appeal, those sort of things. None of those feature in the VAT Act, but they are the sort of necessary conditions you need to allow a sort of action in the First Tier Tribunal to commence at all.
Can I just go to a different point?
Yes, please.
On the same section, so on 83G, the words we're construing is that an appeal outside the time limit may be made only if the tribunal gives permission to do so. Now, at first blush, that looks to me like a procedural power of the tribunal to give permission. So using your procedure substance distinction, it just looks like a procedural power.
I would disagree, and I can show you in due course Callan Forman, which treats very similar wording in the Inheritance Act 8475 as not procedural. But I would say that the substantive point for the FTT in that application is whether to allow the proceedings to commence. The other reason it's not procedure is the procedure is concerned with governing appeals once they are through the door, and this is a substantive or jurisdictional question about whether you get through the door at all. Shall I begin then by showing you the way that these sorts of provision in Taxes Act have been understood by the courts before Markland?
That's data select, is it?
It's perhaps best start with Aberdeen City, which is at tab 18 of the Authorities Bond.
Tab 18.
Tab 18. Page 393 of the PDF.
Oh yes, Lord Barney. Yeah.
This was a judicial review relating to the income tax liability of an individual who worked on jack-up drilling rigs. Clark and Perks, a decision of the Court of Appeal in England, had held that the taxpayer would have been entitled to deductions in earlier years. This was in the pre-self-assessment era, and the taxpayer had appealed against assessments for 2 years, but not appealed against an assessment for a later year. Following the decision in Clark and Perks, the taxpayer tried to appeal against, among others, all 3 assessments. The test for late appeals at that time is set out in paragraph 6 on page 398. The General Commission has allowed the taxpayer to bring late appeals. And the Revenue sought judicial review of that decision on 3 grounds, which are set out as 8. The third of which was that the decision was unreasonable and irrational, which is the one that we're concerned with. Lord Drummond-Young's analysis of that ground begins at paragraph 18, but we can pick it up at 22, which is page 405. And rather than reading out a huge chunk of text, can I just invite you to have a look at paragraphs 22 to 25, please?
So what were the reasons that the commissioners gave for allowing the appeal? Because Lord Drummond-Young says that they were irrational.
Yes, you can see the Commissioner's decision in paragraph 7 on page 398. The key issue in this case was that there was a 6-year time limit for correcting errors or mistakes in returns, and the taxpayer was trying to use a very late appeal to get around the fact that that 6-year time limit had expired.
So the commissioners thought there was a reasonable excuse for not bringing the appeals in time. That the appellant has made sufficient efforts to make the application within a reasonable time because he was working offshore. So if we go to Lord Drummond-Young's questions, paragraph 23, his first question is there a reasonable excuse? And the commissioner said, yes, there was. And the second question is, once the excuse has ceased to operate, have matters proceeded with reasonable expedition? And the commissioners appear to have said yes to that question too. So why did Lord Drummond-Young say it was irrational?
If you go down to just below G,
G.
a third issue is the policy that is to be discerned in the other provisions of the Taxes Act. That policy has been enacted by Parliament and it should be respected in any decision as to whether an appeal should be allowed to proceed late.
Yes.
And in this case, Parliament had said in section 33 of the Taxes Management Act that a taxpayer had 6 years to correct an error or a mistake. And this appeal was brought more than 6 years after the tax year. And so Lord Drummond Young's concern was that by bringing an appeal this late, or by allowing an appeal this late, it would be allowing the taxpayer to get round a different time limit that the legislature had chosen and put in another part of the Taxes Management Act.
But that's always going to be the position if anybody's given permission to bring proceedings or appeal out of time. It's always going to be the case. The legislature or the rules committee, whoever it happens to be, has said if you want to appeal, you do it within this time. And there's a power to allow an appeal to be brought outside that time. And if that power is exercised in favour of whoever it is who wants to bring the appeal or launch the proceedings, then you've got round the time limit.
Ah, sorry, I've not been clear, my lord. The limit in section 33 was not the time limit for bringing appeals. It was a completely different time limit for correcting assessments. And perhaps, and so there was an assessment issued. It was issued on a particular basis. The taxpayer could, at any point in that next 6 years, have said, hold on a minute, there's a mistake in this, I want to correct it. This wasn't the 30-day time limit for bringing an appeal against the assessment. This was a separate 6-year time limit for correcting errors. And so while the taxpayer had a reasonable excuse because the understanding of the law had changed from the Court of Appeal's decision, allowing the late appeal would have allowed him to get round his other time limit, not the time limit for bringing appeals.
I think that the policy that he identifies, I think, is at paragraph 27.
Yes.
Taxpayer should not be able to obtain relief for an error or mistake if his return was made in accordance with the practice generally prevailing at the time. And what seems to have happened in this case is that practice or interpretation of the law had changed.
Yes.
And that's, I think, what he goes on to say at paragraph 29. Yes.
Yes, so it was construed in the purpose of the broader legislative scheme that the decision was made there.
Yes.
Can I then very briefly show you data select, which is at paragraph or tab 24 and page 690.
You say then that the guidance that he gave there was legitimate.
Yes.
So guidance can be given, because he said these are the kind of typical factors which are likely to be relevant.
Yes.
What's the limit? Is it Mr. Justice Marcus Smith in this case said at one point, well, you can't do things which are inconsistent with the statute. You can't give guidance which is inconsistent with the statute.
Yes.
So do you say that here giving what I'll call Denton and White type guidance is actually inconsistent with the wording of the statute properly construed? Is that really what it comes to?
I don't think it is. I think that is one of our respondents' notice points. I think what we are saying is that guidance that narrows a broad discretion, which is what the Denton, Mitchell and Denton guidance does. It says you must give particular weight to these factors. And picking up on the discussion earlier, my own friend, it's clear both that that is what Mitchell and Denton intended to do, to place those two factors at the top table, and regardless of whether that is what was intended by Martins, and Mr. Justice Marcus Smith sort of reserved his judgment on that. He said it wasn't clear whether Martins intended they be given seats at the top table. It's clear that is how Martins has been understood by the tax tribunals for the last 8 years. And paragraph 17 in Cative is an example of that the appeal was allowed because particular weight had not been given to those two factors. That is narrowing the scope of the broad discretion. It's not saying here are things you might want to think about, here are things that are likely to be relevant. It's saying whenever you make this decision, you must give weight to these, particular weight to these factors. And we say outside of areas where the courts or tribunals can regulate their own procedure, you need a statutory hook to justify that sort of narrowing, fettering, constraining guidance.
Well, the particular importance, so the particular factor in Cative was the respecting statutory time limits.
Yes.
You know, one thing you can say about the legislation is there is a time limit,
Yes.
which Parliament put there for a reason.
Yes. But
And it's the only factor that's mentioned in that section, apart from the general power to permit an appeal to be brought after the expiry of the time limit. So what's wrong with saying that's of particular importance? Because it's the only express part of the legislation which tells you anything about when you should be bringing an appeal.
giving it particular importance, the justification for giving it particular importance in Mitchell and Denton was that time limits in...
I'm not asking you about Mitchell and Denton, I'm asking you about section 83. The only thing that's mentioned in 83, apart from the power that we are considering, is the existence of the time limit. So why is it inconsistent to say, well, that's of particular importance, because that's there, that's in the section?
Because the reason for giving particular importance to time limits is that they should be obeyed. When you're told in the civil courts you should do something by a certain time, you should do it.
Yeah.
What section 83 doesn't say is you must appeal by this time. If you don't, you won't be allowed unless the court grants you special dispensation. There's a difference, and this is the point in yes, between saying if you do something after a certain time you need permission, and saying you must do something and there's a sanction if you don't, and we're going to enforce that sanction to encourage broader compliance.
But isn't the sanction obvious? You can't appeal. I mean, that's essentially the reasoning, as I understand it, of a court of appeal in the ISACH case.
Yes.
And the reason why it's then 3.9 is treated as an analogy, because if you can't start an appeal, there's nothing. You're dead.
Yeah.
So, in construing the section, doesn't it actually say what you've just said, that that you've got 30 days to appeal, unless and then thereafter, unless the tribunal gives you permission, you cannot appeal. That means you're then stuck with whatever the decision is.
Well, this is the sort of doctrine of implied sanctions that HISAG talks about, and that yes, suggests is, if not a closed class, then pretty close to a closed class. That what Lord Justice Burst said in yes is that a distinction needs to be drawn between needing permission to do something after a certain time and a rule or order or practice direction that says you must do something by a certain time, and if you don't, there's a sanction. And it is a fine distinction, but it's clear in various of these cases, and the Limitation Act perhaps is another one, the Inheritance Act, that the fact that you need permission after a certain time doesn't turn the failure to do something by that time.
But the point in Lord Justice Bursey's case was somebody wanted to produce an extra expert,
Yes,
which hadn't been dealt with before at all.
yes. But the principle is that simply saying that something has to be, or that if you haven't asked for something by a certain time, you need the court's permission, doesn't turn failing to do that by a certain time into a sanction for which you need to ask the court's relief.
Leave aside the question of sanctions and so on. High Sag says that if you don't appeal within the time limit, and the Court of Appeal, say, does not extend time, then you cannot appeal.
Yes.
Which means you're then left with the decision of the lower court. And that's that. Isn't that a precise analogy with this situation? There's a decision of the revenue which you, as the taxpayer, want to appeal against. If you don't bring the appeal within that time, and the tribunal does not give you further time, then you're left with a decision.
The distinction I say is that what the civil procedure rules say, and we may have to, I said, is that you must lodge your appellant's notice by a particular time. And so it creates a mandatory, and that's where the analogy is drawn from. Whereas what a lot of the late or the appeals time limits say is an appeal may be made within 30 days, or may be made after that with permission.
Isn't exactly the same?
The difference.
At the moment, I can't see the difference. It's just a different phraseology, but the consequence is exactly the same.
The consequence is exactly the same, but in one, you are being told to do something, and in the other, you are, we say, being given an automatic right within a fixed period and a discretionary right after that, so that there's a way you can go through automatically, and after that, you are relying on the court's indulgence, but it's not.
You're not required in the case of court proceedings to appeal.
No.
So there isn't a requirement on you. What the rules are saying is, if you don't appeal within that time, then you cannot appeal.
To put it round another way, you've got a right to apply for permission to appeal within a time frame, and in some cases, like committal for contempt, you don't even need permission, but you still got a time limit to comply.
Let me just turn up High Sag. So if we look at High Sag and look at the rule there,
That's in the supplementary.
that's in the supplementary bundle. It's page 1158, or PDF page 41, if you're looking at, is the paragraph that sets out the ruling of the CPR.
Sorry, which paragraph was it?
Paragraph 21.
20. Yes.
And it begins there, the appellant must file the appellant's notice at the appeal court within such period as may be directed by the lower courts, or where the court makes no such direction 21 days. So it is a must. It's after you've got permission, it's filing the appellant's notice. Yeah. and perhaps it will assist to show the way this distinction was analysed in Cowan and Foreman, which is the 1975 Act case, which is at page 902, tab 37 of the authorities manual.
Can I have that reference again, please?
Page 902 of the PDF is where it starts. Tab 37. We can pick it up at paragraph 29. Which is page 912.
Yes.
And sets out the section that's being considered there. An application for an order under section 2 of this Act shall not, except with the permission of the court, be made after the end of the period of 6 months from the date on which representation with respect to the estate of the deceased is first taken out. And so again, you've got a period where you can do it as of right and a period where you can do it automatically with the court. And if you don't do it within the period as of right, then in a sense, there's a sanction that you're not allowed. And we can see the reasoning of the judge in applying this over the page at paragraph 31. Could I just invite you to read that paragraph, please?
Yeah.
We say that's exactly the sort of analysis that the Upper Tribunal applied in Martland and that the revenue supports here. In paragraph 39, you can see that the appellants advanced 9 grounds of appeal, many of which had sub-grounds. But the one we're concerned with is the second ground, that the judge erred in drawing an analogy between the jurisdiction to grant relief from sanctions and the power under section 4. Lady Justice Aspling considers that in the nature and purpose of section 4 in paragraphs 43 to 49. And again, it's probably quick for me just to invite you to read those paragraphs. 43 to 49, please. And we say that analysis applies in the same way to time limits to bring tax appeals. The CPR and the procedural rules, and McCarthy and Stone, Mitchell and Denton, are concerned with managing a case once it's commenced, not controlling the right to begin it. That time limits for commencing claims don't involve a disciplinary element. They're designed to bring a measure of certainty. They're not designed to punish someone for failing to comply with the rules or practice directions of the courts. Conversely, both in the tribunal and in the courts, once directions or orders have been made, once there are practice directions in place, those should be obeyed. Litigation should proceed expeditiously at proportionate costs, and therefore there is a justification for this disciplinary element. And so we say references to the overriding objective, references to case management powers, that Lady Justice Aspinall was right to reject those emphatically in Cowan and Foreman. And the same analysis applies to.
So where Markman went wrong was to equiparate the granting of permission to bring proceedings after the statutory period with a failure to comply with a rule in the procedure.
Yes, my lord. And that, I think, is our second respondent's notice point, that the equivocation, the analogy was misguided, was wrong. The other provision that we have referred to in our skeleton argument and that we have in the authorities bundle regarding permission to bring late proceedings is section 33 of the Limitation Act. And we have two cases on that, the first of which is the decision of Horton and Sadler, which is at tab 19 of the bundle, page 410. And this takes us back to what is and isn't sort of permissible narrowing of these sorts of discretions. Section 33 allows personal injury claims to be brought outside the limitation period at the discretion of the court. And you can see section 33 at paragraph 8 of Lord Bingham's speech on page 419 of the authorities bundle.
Sorry, paragraph
8.
8. Yes.
There's a discussion of the history of this provision in paragraph 7, that the Law Commission had intended it to be narrow, and the Court of Appeal in Furman and Ellis had construed it to be broader than that. But what we're concerned with is a decision of the House of Lords called Walkley that held that where an action had been commenced within the limitation period, but the writ had not been served.
Sorry, where are you reading from now?
Walkley starts at paragraph 10 over the page on 420. So you can see
Yes.
and there's discussion of the reasoning. So the House of Lords has held that where the claim had been issued but lapsed, then there was no role to play for extending the limitation period because the claimant had suffered no prejudice from. And we can pick up at paragraph 20 with the appellant's criticism of Walkley. and most relevant for our purposes is the third criticism in the fourth line, that the decision deprives the court of the wide and unfettered discretion which legislation is intended to give it. And that was accepted by Lord Bingham in paragraphs 26 to 28.
So the problem was Walkley.
Yes, Lord.
And the rule that the House of Lords laid down there was if you started an action in time, but you hadn't got on with it, then you can't get an extension of time to bring a second action.
Yes.
And so when Lord Bingham speaks, as he did in para 26, of a technical rule, that's what he's talking about.
Yes. Yes, it is a, I would accept it as a greater constraint than the one we're looking at here. But it does establish that there are limits.
Yeah. And in fact, the discretion is not unfettered in Section 33. There are all sorts of things that the court must have regard to. In fact, I very much doubt whether there is any such thing as an unfettered discretion. You've always got some parameters within which it must be exercised.
I suspect unfettered is meant in a relative sense rather than an absolute sense, my lord. But it's the word that Lord Bingham uses. And yes, I accept that there are things that you must have regard to. I accept that in all cases there's requirements to act judicially, act reasonably, but the discretion can be broader or narrower. I can use a broad discretion rather than unfettered, if that.
Where Lord Bingham seems to get to is to say that that's actually inconsistent with the statute as properly read. That seems to be the end of 26. So he says if you look at the...
Because the intention was to give this broad discretion, once you narrow that down, that's...
Yeah. But by looking at the terms of a legislation, the particular legislation, read purposively, no doubt, you work out what the legislation is intended to do and then see whether any guidance which is given in accordance with it is inconsistent with that purpose. Or subverts it.
Yes, subverts is perhaps a better word, because in here it's not that it's contrary to any particular aim, it's that the aim was to give a broad discretion, and by narrowing it's that subverts that broader aim. And as I've accepted, this was a fairly substantial restraint. But if we look at the decision of the Court of Appeal in Sayers and Hunters, that is, in my submission, a much a narrower constraint that was still held not to be acceptable. And this is again a Section 33 case, where the Deputy District Judge allowed the claimants.
Where do you find that?
Page 700, tab 25.
Tab 45?
25.
25.
And as you'll see, initially permission was granted to bring the claim outside the limitation period. An appeal was allowed against that by a circuit judge, who said that Section 33 imposed a particularly heavy burden on a claimant seeking to persuade a court to exercise its discretion. And that was based on a judgment in the Court of Appeal in KR and Bryn Allen Community, which you can see at page 707, paragraphs 38 and 39. And there's then a review of Lord Justice Jackson reviews the authorities. And can I just show you, because he refers to his conclusion, the paragraph quoted at paragraph 47 on page 710, from the judgment of Lady Justice Smith.
Yeah.
And then just passing over it on the following page at 52, first sentence, Lord Justice Jackson says, "I must confess that I'm not one of those who welcomes the incrustation upon simple words of Section 33 of a vast tangle of case law." And so there's perhaps a danger. You can have too much of a good thing when it comes to giving guidance. And his Lordship's conclusions are at 53 to 57. And I'll let you read those, but broadly it's that he agrees with Lady Justice Smith.
So the effect of this case is that you shouldn't get too hung up on whether the burden is a heavy one or not a heavy one.
Yes, my lord.
That's what it actually
Yes.
decides.
But it's saying that saying it is a heavy one is a fetter on the broad discretion granted by Section 33. And that's a different sort of restriction to that considered in Walkley. It doesn't prevent the court considering all the circumstances. It doesn't determine any category of cases. And in that way, it's much more similar to what we're concerned with in Markland. But it was still subverting the purpose of Section 33. It was still an impermissible restriction on a broad statutory discretion. it's paragraph 55 in Horton, the House of Lords stressed the court's discretion is broad and unfettered. In my view, those comments make it difficult to maintain the claim's burden under section 33 is necessarily a heavy one.
And in fact, the appeal was dismissed.
Yes.
Is this case under section 33, is it really about something a bit different? Because what was being said, I think, was that the approach that the judge had taken to the exercise of discretion was wrong because he had misdirected himself on the burden, said it was a very heavy burden on the claimant where it should just be a burden on the claimant. And that was the wrong approach to the interpretation of the statute. Whereas what we're dealing with, possibly, is everybody agrees that the tribunal has a discretion to extend time. But this case goes to the factors that you take into account when you are extending that discretion, and that really the argument here is about the weight to be given to some of those factors rather than anything else. That's what we're discussing here.
I think in both cases it's about starting points. That what Martin says is the starting point is you've got these two factors that are in Rule 3.9, and you must start by giving them significant weights. And in effect, it creates a heavy burden. You've got these factors that weigh against granting permission.
I'm just wondering if we're dancing on a very small pinhead here, which is that everybody agrees that it's a discretion. I suppose you say that the Upper Tribunal has no role in providing guidance, but in fact, you accept they can provide guidance as long as it's just saying you can or should take the following things into account. That's okay, isn't it?
And it's tied to the
particular statutory power. So that the real issue is whether Martin over-eggs the pudding by saying that you should give Denton-style particular weight to these factors, whether that was a wrong turn and amounted to an impermissible fetter or not.
Yes, my lady, I think that's perfectly put in.
But if Martin had just said you should take these two things into account, that would be okay on your case.
I think on my case on HMRC's ground of appeal, I think I do subsequently say that the relevance of those two factors is contrary to the purpose of the legislation, but that's effectively...
Okay, so that's your stage one, but if there might be a world in which you say, well, it's not contrary to purpose, it's just relatively where weight should be given to them, and that might be this.
Yes, if Martin had said you should give particular weight to the length of the delay, I would say it's obviously right that the length of the delay is relevant, but giving it particular weight is going beyond the statutory purpose as anyone can interpret it sort of purposefully in the context of the legislation.
I'm sorry, I'm still a bit lost. You accept that the Upper Tribunal can give guidance
Yes.
on the exercise of the power to permit an appeal out of time?
Yes. Yes, I accept that that's what happened.
Do you accept that the Denton criteria, that is the length of a delay, the reason for the delay, and all the circumstances of the case are relevant to the exercise of discretion?
Yes.
So I don't at the moment see the vice in the Upper Tribunal saying the Denton factors should be taken into account. It is only when Martin goes on to say that significance must be attached to factors A and B, that is the length of the delay and the reason for it, that you say the Upper Tribunal has gone wrong. Is that right?
The Denton factors, my lord, the concern is with just to make my position clear, the two factors in 3.9 are the importance of complying with time limits, or complying with rules, practice, directions and orders strictly, and the importance of litigation being conducted efficiently and at proportionate cost.
And you say neither of those apply to...
And I say two things, and they are I think, discrete arguments. One is I say that where Markman says you must apply particular weight to any factor, that would be a fetter on the broad discretion. And that is in my submission, the conclusion of Mr. Justice Marcus Smith in the Upper Tribunal, that putting weight on those two factors isn't tied to the language of legislation construed purposefully in its context.
It's not within section 83G properly construed.
Exactly. But I also say, and this to a certain extent is the Cowan and Foreman point, that the need to comply with rules, practice, directions and orders doesn't apply to something that is before litigation. And the need for litigation to be conducted efficiently at proportionate cost, again, doesn't apply to something before you start. But those are two separate arguments, the weighting and the relevance of those two factors.
Do you accept that the importance of the time limit could be relevant?
Yes.
Because that's really what they're talking about in these tax cases, isn't it? It's not really the one about the conduct of litigation, it's the one about the importance of the time limit. The statutory time limit in this
The
case.
statutory time limit, but I say that where particular weight is given, and I think we perhaps get into very fine margins here, but the reason particular weight has been given in other context is because compliance is sort of a good in itself. And I say that doesn't apply here.
Because you say that the particular weight of compliance is a good thing if you're in the context of up and running litigation, because you want everybody to do everything in time. That's a good thing. But this is your point about we haven't got that far here. We're at a different stage, all I'd say is, where you're thinking about starting with this litigation.
Yes, and for what it's worth, and I think this is common ground, you might even be at a much earlier stage in that. One of the time limits that was introduced in 2009 is the one in section 49 of the Taxes Management Act. And what happens for direct taxes, which is what the Taxes Management Act is concerned with, is you have an inquiry into a tax return, or you have an assessment, and then there's a closure notice for the inquiry, or there's the assessment. And the first stage is you appeal to HMRC. And once you appeal to HMRC, there is an indeterminate length of discussion with HMRC before you get the view of the matter letter, where you can request a review and before you go to the tribunal. And section 49 deals with if you're late appealing to HMRC. So that's not even getting into the tribunal. That's potentially years before the tribunal. I had a case come out earlier this month where the time between appealing the assessment and notifying the appeal to the tribunal was more than 15 years. And so litigation was long in the future. And so these time limits don't even necessarily apply to litigation as they've been understood by the FTT.
Just before we break, can I ask you to go back to Markland, tab 35, volume 4, page 879. Paragraph 44 is giving structured guidance.
Yes.
And I'd just like to understand which bit, if any, of paragraph 44 you say is wrong. First point is the starting point is that permission should not be granted unless the FTT is satisfied on balance that it should be. Do you agree with that, or say that's wrong?
We can possibly take this short. Both the Upper Tribunal and I say that all of paragraph 44 is permissible guidance on how to approach this.
44 is, so that's all permissible.
45, it's the sixth sentence of 43.
It's the first sentence of 45 that you reject to, is it?
Yes, my lord. And that Mr. Justice Marcus Smith objected to. He also said that 44 was all a perfect approach to this, but 45 was where the Upper Tribunal went wrong.
So that's really what we're focusing on.
Yes, my lord. and there was some discussion this morning about whether 45 was saying that particular weight should be attached to those two factors. And as I said, Mr. Justice Marcus Smith didn't express a view on that. He said it could be read as just saying they are factors to take into account, which he said was an acceptable approach.
What was Mr. Justice Marcus Smith saying was wrong?
The way that Martland has subsequently been understood is that sentence does require particular weight.
And in particular, Khatib, is that?
Yeah, in particular, Khatib is the example we have in the bundle.
Yeah.
Paragraph 17 of Khatib, which is the next tab 36.
Do you say that the judge, Marcus Smith, was right to characterise this as being a top seat at the table type approach? That was a correct characterisation of Martin as interpreted and applied by tax tribunals? Yes,
that is how I say the tax tribunals have applied it. I don't think that's in dispute. But paragraph 17 of Khatib, which is at page 891,
Yeah. You say that's wrong in law.
I say that's wrong in law, but that says that although the FTT acknowledged...
Sorry, I've lost the paragraph. Can you give me that? My fault.
17, 891 at the bottom of the page. And I say that's an example of the Upper Tribunal finding that it was an error of law not to give particular weight to those factors.
Yes.
So the issue for us is not whether that was right or wrong as such, but whether that strayed beyond the proper boundary by creating a fetter which was not envisaged by the statute.
Yes, my lady.
So, on your analysis, would it be open for the judge of the First Tier Tribunal, considering an application to extend time, to say, I consider that compliance with statutory time limits is of particular importance, and for another judge in the FTT to say, well, I don't?
The outcome of the decision in Martland and the ground of appeal that we're talking about at the moment, HMRC's ground of appeal, would allow a judge to do that, to look at the factors and say, in this case, this one is important, and I attach weight to it. And in another case, judge say, well, I'm not going to attach much weight to that. And that the weight that the judges choose to apply to those different factors is not something that is reviewable on appeal, outside of irrationality. I have one more case to show you on broad evaluative judgments and constraints on them, but that's
Right,
probably best
should we
said
do that
for
at 2
lunch.
o'clock?
Yes, ma'am.
2 o'clock.
Court rise available.